Good morning. Welcome to the broadcast. My name is Kylie Walker. I am the Workplace Relations Advisor with the Printing Industries Association of Australia. Today I'd like to take you through the world of termination over the next half an hour or so. For those new or those familiar already with the topic of termination, my goal today is that we will give you a general understanding of the many aspects in relation to termination of employment. Let's be honest, terminating an employee is never easy and can often be emotional for the employer as it is for the employee. It can be for a variety of reasons, including redundancy, misconduct, or abandonment. Please remember throughout today's webinar, the information is not absolute advice. You should always contact us with your particular circumstances so we can provide the most accurate and relevant advice to meet your needs. We will look at the various forms of terminating an employee's employment and how the law interacts with them. Let's take a look at the overview of today's session. And today we will cover the most common types of termination. We'll look at what is an unfair dismissal and the claims process. If we move over to the next slide, let's look at, for today's purposes, the most common 5 types of termination. The first, resignation. Now, the resignation can be at the employee's initiative. This is accepted and formalised by either a verbal acceptance or a written acceptance by the employer. At the time, if it is possible, ask the employee to put their resignation in writing. This formalises the process and the resignation with an end date, thus making it more difficult for any future discussions or confusion or misunderstanding between the parties. Secondly, we look at poor performance. Prior to a termination related to poor performance, employees must be warned about their unacceptable conduct. For example, they should be provided with the time to correct their conduct before a decision is made to terminate. Termination should always be considered the last resort. A warning provides a formalised means for advising the employees that something that they are doing, which could be a specific behaviour, attitude, conduct at the time of the warning, is unacceptable, and that failure to improve their behaviour may result in termination of their employment. Remember to issue and provide the warnings at the time. Don't wait. There are 2 kinds of warnings that we'll touch on today. These are verbal and written. Verbal warnings, sometimes it can be appropriate to stop and consider if the person knows what they're doing wrong. Have they been told? Have they been given the chance to improve? In these situations, a verbal warning may be appropriate, just to let them know that their behaviour, performance, attitude, or conduct is not meeting your company expectations and what is expected of them. These cannot be relied upon to show procedural fairness before the tribunal. Next, let's look at written warnings. Some circumstances are appropriate to skip straight to a written warning. These may be for language directed at fellow employees or a supervisor, which is of highly explicit or even an aggressive nature. In some circumstances, this could also be due to lack of time or the seriousness of the behaviour, and this may even lead to what is defined as serious misconduct, where termination may be appropriate. Serious misconduct refers to the very unique behaviours and circumstances which is entirely dependent on the circumstances. If you believe a worker in your company is guilty of misconduct or serious misconduct, please do call us so we can talk you through the best and appropriate advice. Do remember in these situations, procedural fairness, which is following through with an investigation of the incident or the behaviour before termination, is vital. Serious misconduct is the only instance where summary dismissal or instant dismissal is permitted. This is termination without notice. This is by definition of the Fair Work regulations the act of the behaviour that causes imminent and serious risk to health and safety of the person or others. The behaviour that causes imminent and serious risk to the reputation, viability, or profitability of the employee's business. The theft, fraud, assault, intoxication, drugs or alcohol, refusal to carry out lawful and reasonable instructions. It is imperative that you undertake investigation of the alleged misconduct before termination. When looking at an investigation, this may involve reviewing the damaged goods, reviewing documents, reviewing any video footage, interviewing any witnesses or others involved. Consider when interviewing employees, put the allegations and the issues to them to respond. Remember, you may have to conduct the interviews more than once. And during this process, it is imperative that you document all the meetings and the findings of this investigation. Whilst under investigation at this time, it is okay to stand down the employee with pay. They should be notified of this. During the investigation, it is fine to take a break. Remember again to call us during this period if you're unsure. Do make sure you have evidence and all the witnesses involved and are clear as possible before the termination occurs. Do remember to follow any company policies or procedures so you can show procedural fairness was showed. Now for the next two issues just discussed, summary dismissal or a warning path once followed, if appropriate, to go ahead with termination. Advise the employee that you want to have a meeting to discuss the ongoing employment. Advise them of the date, the time and where. You may want to offer them a support person. Although there's no obligation, you cannot deny if requested. If they want to bring and advise you, they wish to bring a support person. The attendees should be only directly related to the circumstances. For example, their immediate supervisor, manager, and the employee. During the meeting, advise the employee of their latest behaviour and give them examples. Reiterate to them what has been discussed, and if they have been involved in warnings in the past, do refer to these. Explain to them the company expectations, that they have been made clear, and where they have failed in their behaviour or actions to follow these instructions. Remember, there is a certain notice period required prior to termination. You may choose not to have the employee work out their notice period, but then you are required to pay out that notice period in lieu. Entitlements to be paid out after termination. Request any return of company property before they leave, their phones, their computers and keys. Do provide a termination letter. The letter should be issued after the meeting, and that could be posted. Any entitlements, including annual leave, long service, should also be paid out. By all means, do send any letter through to us for checking before issuing. Next, we look at the third most common type of reason for termination is redundancy. Redundancy, by definition, is when a position is no longer required to be performed by anyone, i.e. you will not replace the position in the foreseeable future. Unfortunately, in my experience, there is a misconceived belief that employees cannot make a claim against an employer after they have been made redundant. It is always wise to consider and keep in the back of your mind when planning for redundancy that employees can make an application and file for this type of unfair dismissal. If this continues and the progress is on, the onus is on the employer to prove that this was a case of genuine requirement for the ending of the person's employment. This could be by way of losing a contract or showing how that individual was selected for redundancy apart from his colleagues. Let's now look at the specific reasons for the justification of a redundancy. These could be, but not limited to, a reduced profit, where the business can no longer afford full-time position in a particular area, or the company is outsourcing a particular area that is no longer needed. Be prepared to have to prove these reasons. Do keep all your paperwork. There's no need to show employees, but you should keep them just in case you have to prove there was a genuine redundancy. A skills matrix should be drafted. In this matrix, this should be done before the employee is terminated and selected. It is recommended that you undertake this matrix to show which position was chosen and why. Maintain the highest level of skill ability in the department. In the selection, try and concentrate on the employee's good points and qualifications rather than the bad ones. Do use a job description to look at an objective way to set out the criteria they're going to be assessed against. You may still consider things like attitude, past issues, but do not make this the sole criteria. Be objective. It is to maintain the most and skilled employees. If possible, redundancy should be the last option, and other alternatives should be explored and considered. Could you change employees who are willing to a part-time status from full-time? Can casual workers be eliminated or hours reduced to keep those who are full-time? Are employees willing and in agreement to have their pay reduced for a certain period? You must get genuine agreement from the employee before reducing any hours of pay. Do again remember to give us a call for assistance through this period. Remember to have a look at the requirements in your various awards. They do require consultation with employees and their representatives. This may include the union, if appropriate or if requested. After the decision has been made, you will need to sit down and advise the employee of the redundancy. Do provide a letter stating the reasons. Again, we are more than happy to have a review of the termination letter prior to sending this out. And as always, do remember to document everything. Now, the fifth and most common reason for termination through the abandonment of employment. This is when an employee fails to present for work without notifying an employer. This is usually 3 days of evidence that the employee may have abandoned their employment, but then a total of 14 days of absence without contact is needed before the employee can be deemed to have abandoned their employment. Remember that you, as the employer, should continue to contact the employee during this period. This could be via phone, letter, or text. Under the Graphic Arts Printing and Publishing Award, a letter should be sent after 14 days advising the employee that the company considers they have abandoned their employment and all entitlements will be paid out accordingly. Now we will look at the next slide, which is an unfair dismissal claim. An unfair dismissal is most common claim made to Fair Work Commission. However, there are remedies which are available to employees, which we will discuss shortly. With unfair dismissal, there is a jurisdictional limit. This is a 1-year service if there are fewer than 15 employees. There is a time limit of 21 days to make the application. In terms of formality, there is an initial conference, and this is most commonly held over the telephone. Then, if this does not resolve, there is a hearing in person. The remedies. These could be up to a maximum of 26 weeks pay or reinstatement or back pay. Again, this is dependent on each set of circumstances. As an employer, you might ask how it is determined by the Fair Work Commission that a dismissal is unfair. Unfair dismissal is defined under the Fair Work Act 2009. A person who has been unfairly dismissed, if the Commission is satisfied that the person has been dismissed and the dismissal was harsh, unjust or unreasonable, and the dismissal was not consistent with the Small Business Fair Dismissal Code, and the dismissal was not a case of genuine redundancy. Section 385 of the Fair Work Act 2009 states, legislation prescribes a number of things to take into consideration by the tribunal when determining if dismissal was harsh, unjust, or unreasonable. To give some relevance and timeliness to the decisions on recent cases that the Fair Work Commission makes, I will now take you through a decision made this year in relation to the culture of swearing undermined the gravity of an employee's conduct. McCain's Foods earlier terminated an electrician for serious misconduct. This was in relation to an altercation with his supervisor. The employee claimed the dismissal to be unfair. In this situation, although the employee was aggressive, the supervisor had, by his behaviour and conduct, initiated an aggressive confrontation, resulting in both the parties physically grabbing at each other. The Commission found that the workplace had a history and environment of using foul language by both the managers and the employees. The Fair Work Commission took into account the service of 20 years, the workplace culture, and the facts of the incident. The Commission determined that the termination of this worker was excessively harsh, and in their decision, they ordered reinstatement. By this decision, we see this as a timely reminder for employers that the standards of behaviour that are set in your workplace will be reflected by your employees in their conduct. If the standards are set and they become very obvious and very quickly when an employee's conduct falls short, these should be managed. Finally, in relation to termination, there are several types of other potential claims or avenues that may be lodged to the relevant bodies in relation to claims. These are adverse action, underpayment, discrimination, health and safety, or more generally lodged by your insurance agent, simply known as work cover claim. Now, this brings us to the end of our seminar. We have covered a lot and what to do in a number of situations when terminating employees. Do remember, this is not absolute advice, and you should always contact us before you take any steps to terminate an employee's employment. Today, we have covered the usual types of reasons for termination, and we make a range of potential claims an employee may take. As always, we do recommend you contact us before you terminate to discuss, and we will give you an objective advice should the termination take place and you can defend yourself. Some things to take away are: make sure in all situations some type of fair process is followed. Make sure you follow any policies and procedures you have with your company. Check with us to make sure you adhere to all relevant statutory entitlements. Document and keep everything. Do remember that no type of employment termination will exempt you from legal action. The employee always has the right to file an application, but it's about establishing a case that shows that there is procedural fairness and the dismissal was not harsh, unjust, or unreasonable. Again, I thank you for your time today. And do not hesitate to contact us. Thank you.